Bom dia, buenos dias, good morning, ladies and gentlemen. Welcome to the ALARB SIAC Americas webinar, Arbitration in Latin America, the State of Play. My name is Eugenio Gomez-Chico, and I am the Deputy Head for Americas, and I am pleased to be with you today. Some housekeeping matters. You may send your questions to the panelists using the Q&A function. As we have very limited time, the panelists will try their best to address as many questions as possible. From SIAC Americas and ALARB, we couldn't be happier with the lineup we have prepared for today. Our panelists today for this webinar are Professor Lawrence Wu, member of SIAC Court of Arbitration, and independent arbitrator at the Arbitration Chambers in Singapore. Mr. Alvin Yeo, senior counsel, member of SIAC Court of Arbitration, and chairman and senior partner at Wong Partnership. Mr. Alfredo Goulart, partner at Goulart Paya Escurra. Mr. Kevin Nash, deputy registrar and center director at the Singapore International Arbitration Center. And Mr. Eduardo Zuleta, partner at Zuleta Abogados. Moderating this session is Ms. Julie Bedar, member of the SIAC Court of Arbitration and head of International Arbitration and Litigation Group at Skadden, Arps, Slade, Mager and Fromm. We hope you enjoy this session. I leave you now with Julie. Julie, the floor is yours.
It's very good to be with all of you. And this event is special to me in the following sense, in that it brings my worlds together. Eugenio mentioned that I'm a member of the court, but I also do, of course, a lot of work in Latin America. And I'm extremely pleased that we're able to bring today this panel that really draws together the experience, the expertise, the knowledge, and the wisdom of our panelists to talk to us about this work of SIAC in Latin America. And I think the audience today does reflect exactly what we wanted, which is the mix of interest both in Asia, Latin America, and of course also North America, given the ties to Latin America. So I think what we would like to do, and I think you might find that of interest, it's usually the case that many of us, whether we are familiar with the terrain or we are not, that we like to hear directly from SIAC with respect to their own statistical knowledge and experience of these cases, because this is, of course, information that no one else really can have and share other than SIAC, because our own individual experiences tend to be a little bit more anecdotal and less scientific. So our proposal for you today is for us to begin with Kevin Nash so that he can educate all of us a little bit on SIAC and the Latin America landscape.
Thank you, Julie. Good evening from Singapore. It is really a great pleasure to be here today and to be speaking to our users in Latin America. As a starting point, I would like to say from the SIAC Secretariat, we are absolutely thrilled to have the SIAC Americas office with Adriana Usan and Eugenio Gomez-Chico. Adriana is based in Singapore right now. Eugenio's in Mexico City, but they will be going to New York. And what we really have for our Latin American parties is we have 24 hours a day. So please do reach out to Adriana and Eugenio. They bring a tremendous amount of experiences, counsel, academia, arbitrator, and we're really thrilled to have them with us. Looking at SIAC and explaining SIAC, I think I really have 3 or 4 stories that summarizes the ethos of SIAC's case management experience. And one of them involves Adriana when she worked in the SIAC Secretariat. The first is an emergency arbitration. As many of you would know, these are often filed on a Friday night. That's one of the advantages of emergency arbitration. Courts typically cannot accept an application on Friday night. We had one of our SIAC counsel that stayed up through the night in the hearing. The hearing ended at around 3 a.m. The emergency arbitrator turned around the award over the night. We scrutinized it that night and then were able to issue it the very next day. Also in the context of emergency arbitration, we had an urgent application for joinder. A claimant had a reliefs requested against 2 respondents, but one of them was a signatory. So the SIAC court had to take an urgent decision on joinder before the appointment of an emergency arbitrator. We also had a case with a 120-day clause ensconced within the arbitration clause. So the award had to be rendered 120 days from the constitution of the tribunal. The procedural schedule was such that we received the award at the SIAC Secretariat on day 119. We're quite nimble with the scrutiny process at SIAC, so we're able to review and approve that award in one day. And this is something that often happens, say, in a case conducted under our fast-track expedited procedure. We are able to turn around that review very quickly. And then as far as Adriana goes, we had a very tricky issue of jurisdiction where we were advising a tribunal on the competency of SIAC. Adriana and I used to sit beside each other in the SIAC Secretariat, and that jurisdictional issue ended at around 4 or 5 in the morning. To give you some background on SIAC, we are in our 30th year of operation. Last year we had 1,080 cases. Almost all of these were administered and almost all of these were international. That's one of the things that we're seeing at SIAC is that a majority of the cases have no connection to Singapore at all. So you could have a case where it's a Brazilian party and a Japanese party, and they're choosing to have the case administration at SIAC. There's a lot of flexibility under the SIAC rules, so you can choose to have a seat in Singapore, Sao Paulo, Mexico City, New York, Houston, Miami, as the case may be. So you can have the case administration at SIAC, but of course you can choose to seat your arbitration anywhere, choose the governing law of the arbitration agreement. This is all at the discretion of the parties. One of the things when you're choosing an institution and to have confidence in an institution, you're really looking at the people behind the institution. And we are very fortunate at SIAC to have the SIAC Court of Arbitration. Of course, Julie, Alvin, and Prof. Lawrence Boo are all members of this SIAC Court of Arbitration. Gary Bourne is the president. He's an American sitting in London, Lucy Reed in New York, and Kavinder Bull as vice presidents in Singapore. So you also have the court that is running 24 hours a day. And the reason why the Court of Arbitration is so important when you're choosing an institution, because the Court of Arbitration decides all of the most important questions in an arbitration. So as a secretariat, we are 16 arbitration lawyers in the secretariat, but it's this SIAC court that is deciding procedural elements like a prima facie objection to jurisdiction, a pre-constitution application for joinder or consolidation, challenges to arbitrators, and general case management oversight. This is all decided by the SIAC court. In terms of SIAC's case management, we really have structured administration. So if you're looking along the continuum of case administration, you have light touch institutions and you have structured institutions. What we try to do at SIAC is we really try to customize the case management experience, and we listen to the users. So we're an institution in our 30th year of operation. So we started with 2 cases, and we now have over 1,000 administered cases, but we are still prioritizing the user experience. What you want out of an institution is an institution to look at what's really happening in the case, to not just apply milestones. So you see this, for instance, in our cost determination process. SIAC operates on an ad valorem basis. So it's fixed fees subject to cap for administration fees and tribunal fees. What you want the institution to do when determining the cost is to look at what's really happened in the case. And just because an award or just because a case has went all the way to an award, it's not necessarily going to be the maximum. We want to see and really do the forensics on what's happened in the case. Some of the elements that have really resulted in users choosing SIAC is the provisions we have to save time and costs. So I discussed emergency arbitration. This is enormously popular at SIAC. We've had 117 applications for the appointment of an emergency arbitrator. Importantly, in both Singapore-seated arbitrations and arbitrations seated outside Singapore, these emergency arbitrator orders and award are enforceable in Singapore as though they're an order of the High Court. We also have a procedure for fast-tracking arbitrations, an expedited procedure. This is where an award is made 6 months from the constitution of the tribunal. We've had more than 600 of these applications, and this has proven really popular. So the president, when deciding these applications, also has the discretion to appoint a sole arbitrator. So if you're drafting a suite of contracts, you can have a 3-member clause for the very high value disputes, but you also then have the flexibility to have an arbitration before a sole arbitrator if it's, for instance, under around USD 4.5 million. SIAC also introduced a procedure for the early dismissal of claims and defenses. So this is really borrowing from Rule 41.5 of ICSID, but also extending it and applying it to both claims and defenses. So what we're seeing there is that parties are taking really this tool from investment arbitration and summary judgment and striking out, and now importing it into commercial arbitration. This can be very valuable, say, if you had a respondent that had many heads of counterclaims, some of which were outside the 4 corners of the arbitration agreement. A party can apply to strike out certain of those heads of counterclaim at an early stage. We also have provisions to deal with multiple contracts and consolidation. This is important, particularly because under the SIAC rules, it does not require identity of the parties. So if you were, say, in a big construction dispute and you had a contract between the owner and the contractor and the subcontractor, and all the way down the line, if there were the necessary connecting factors and the arbitration agreements were compatible, you can have those collapsed all into one arbitration, which will result in a very big cost savings. Finally, in addition to the SIAC commercial rules, we are starting to receive more and more cases from state entities, state-controlled organizations. We also released the SIAC investment arbitration rules. There's a lot of discussion about whether or not there needs to be incremental or systemic change to the ISDS regime. What we are trying to do at SIAC is take some of our commercial expertise, our reputation for being able to conduct arbitrations efficiently, and apply this to the investment space. So we are, again, very pleased to be able to have this engagement with our Latin American users. We are seeing more and more cases from Latin America, and this is really following the inflows and outflows in the economy. So trade between the Asia Pacific and Latin America, I think that parties increasingly are going to be looking to Singapore and SIAC to help resolve their disputes. Thank you, and I will pass back to you, Julie.
Many thanks, Kevin. And I've been picking up on what you just said in terms of the interest of Latin American parties and using SIAC. I think what we're going to do next is turn it over to Professor Lawrence Bu, so he can tell us about what it means to be arbitrating in Singapore and choosing Singapore as the place of arbitration. Although, as Kevin noted, of course, there may be no ties whatsoever to Singapore, but that's not why Singapore may be chosen as a seat. And Professor Bu, and maybe I should call you Prof, as I understand many others do that. So Prof, can you tell us about arbitrating in Singapore and what that means?
Thank you, Julie. Let me just say that I'm so thrilled to be here, especially sitting with Julie and the renowned in Latin American states. Let me just say also that I think Kevin has said enough about SIAC. So let me just share with you my experience here in Singapore and maybe encourage people over where you are to say what we have experienced in Singapore may be something you can experience elsewhere as well. You know, I want to share with you our experience of how we in Singapore develop ourselves into a leading dispute resolution hub. I start by saying that the Singapore government has since 1991 set about building the dispute resolution infrastructure for Singapore to cater to the increasing number of international commercial disputes. One of the first steps that has been taken is actually in 1992 was to allow foreign lawyers to take part in international arbitration in Singapore without the need for being admitted to practice in Singapore. The usual working permits for foreign lawyers and arbitrators undertaking cases in Singapore has also been waived. So there is no need for anyone to seek any approval to come and work in Singapore for that purpose. One of the first steps in promoting arbitration, of course, is in Singapore is the adoption in 1994 of the UNCITRAL model law on international commercial arbitration. The reason is that we want to align ourselves to the arbitration laws with the recognizable international system. Prior to that, knowing that most of you who know the history of Singapore, we were once a colony of England, and therefore due to our English legal heritage as a former British colony were adapted a version of English arbitration law and followed English arbitration practices. The adoption of model law, however, helps to put Singapore on a different framework. It puts us on the international map for dispute resolution. With model law, parties from different countries choosing to arbitrate in Singapore has the assurance that they will not be working in an unfamiliar system, but a system that is transparent and familiar to international lawyers. Those of you who have been involved in international disputes will realize the advantage of working in a system you are familiar with. Model law has, to a large degree, therefore, leveled the playing field for parties from different countries. Apart from adopting model law, the Singapore legislature also is very sensitive to feedback from international users of arbitration, to the lessons learned from past cases. So it enacts very fast and change laws, make amendments to laws to ensure arbitrations are not derailed unnecessarily by applications to court. One important move in the Singapore legislature was made to transfer the court's default appointing powers of arbitrators to the SIAC. This removed judicial interference at the commencement stage of arbitration, as well as saved a lot of time and tedious procedure of serving appointment applications papers to the judicial and counsel channels. Singapore law empowers arbitral tribunal with the same powers to grant relief and remedies in the same manner as a High Court judge would in civil and commercial matters. It gives the tribunal a wide range of powers to grant interim measures in support of arbitration, and at the same time, any interim measures imposed by the court is always subject to the tribunal's final decision. In other words, interim measures granted by the court may be varied or nullified by arbitral tribunal. I suspect that the model law amendment in 2006, Chapter 4A, probably drew inspiration from Singapore legislation by giving a lot of powers to the arbitral tribunal. More recently, the law has also been amended to give effect to decisions of arbitrators or the emergency arbitrators orders on interim measures, to give effect to those orders made by the emergency arbitrators, which Kevin has shared with us. Apart from being a party to the New York Convention, Singapore takes active part in promoting international dispute resolution and has participated very actively in a lot of UNCITRAL meetings. Most recently, we signed on to the UN Convention on the International Settlement for Agreements resulting from mediation, which aptly called Singapore Mediation Convention 2019. Coming back now to more bolts and nuts. In terms of practice of arbitration, as with many common law jurisdictions, Singapore's arbitration followed English practice. And so for far too long a time, most of our arbitrations were conducted on what we call an ad hoc basis, ad hoc arbitration. In 2004, a major shift came through the implementation by SIAC of a fully administered arbitration, which Kevin just shared. We can tailor it to parties' needs, but generally it is a fully administered arbitration. Following very much in the steps of the ICC, SIAC's administered arbitration won over parties from many Asian countries, particularly China, India, and Southeast Asian states. India in particular has embraced administered arbitration because of the influence, I suspect, of SIAC in India. I think Kevin did not share SIAC's case figures. I'm sure he will do so later if he's prompted by anyone. But for the record, the most popular seat in Asia for ICC arbitration is in Singapore. And Singapore now lies as the 4th most popular in the world, based on the 2019 ICC statistics. One important secret that, or I wouldn't say secret, it's no longer a secret, of Singapore's success in international arbitration is its judiciary. In fact, it's one of the key factors that makes Singapore palatable and in fact attractive to many disputing parties is the judiciary. Despite the fact that the legislature has trimmed its powers over the conduct of arbitration, the Singapore judiciary is not hostile to arbitration. In fact, it has become one of the most stoically supportive of arbitration. It has acted consistently with legislative intent, refusing to intervene in ongoing arbitration, and takes a strong stand in favor of upholding arbitration agreements and arbitration awards. Setting aside arbitration awards are rare. Refusing enforcement of foreign awards, I think you hear once in many, many hundred cases. Also, apart from SIAC, I want all to know that Singapore houses many international arbitration bodies. The ICC Court of Arbitration has an office in Singapore. The AAA ICDR has an office in Singapore, the only one in Asia. The PCA has a base in Singapore. The WIPO Arbitration and Mediation Center has a base in Singapore as well. And the good thing is they're all housed under the roof of Maxwell Chambers, easily the world's leading arbitration facility one can find. In my view, it is actually the go-to place for any user having a dispute in Asia. It has all that you need to host any hearing. Well, Singapore may be far from South America and the Caribbean, but with COVID-19, COVID-19 has in fact made the world much closer. Although we are far in terrestrial distance, we are now so connected by technology. This event is such an example. Let me also remind ourselves that the economic cooperation between Singapore and Latin America and the Caribbean is increasing steadily. Despite a slowdown in global economy, Singapore's trade with Latin America and the Caribbean reached 18.5 billion in 2019. Singapore has concluded free trade agreements with several Latin American countries, Costa Rica, Panama, and Peru. Chile, Mexico, and Peru are all members of the Comprehensive Progressive Agreement for Trans-Pacific Partnership, CPTPP, which includes countries like Australia, Brunei, Canada, Chile, Japan, and Malaysia. Singapore is currently also negotiating FTAs with two American economic blocs, so Latin American economic blocs. Mercosur, which comprise Argentina, Brazil, Paraguay, Uruguay, as well as the Pacific Alliance, which consists of Chile, Colombia, Peru, and Mexico. I anticipate a surge in economic activity between South American businesses and Singapore, and Southeast Asian nation states, ASEAN economies, and even with China and India. There it is, lies the future of international arbitration as well. So let me welcome you all to Asia, with Singapore as an easy landing zone. Welcome to Singapore.
Many thanks. We're here. You can count with us. I'm going to suggest to all of you that having looked at or heard from Professor Bu about the choice of Singapore as a place of arbitration, that we turn the table around and that we look at arbitrating in Latin America. And of course, you can pick also a Latin American seat, and you can appoint Latin American arbitrators in an SIAC arbitration. And to address the topic of arbitration in Latin America, I think many of us could hardly think of a better speaker on these issues than Eduardo Zuleta, who with many colleagues really developed and made Latin American arbitration into what it is today. So Eduardo, could you tell us about arbitrating in Latin America?
Thanks very much, Julie. It's really a pleasure to be here and a pleasure to share a panel with you. There's a sort of a myth that has been created about the so-called culture of Latin American arbitration. And the myth goes more or less like this. Latin America has been reluctant to accept arbitration, but arbitration has evolved during the second half of the 20th century, thanks to the New York Convention, the Panama Convention, the UNCITRAL model law that overcame the Calvo doctrine that prevailed in the region. Latin America has been perceived as hostile towards international arbitration. However, the truth is that there's some lack of understanding of the practice of commercial arbitration in Latin America. And there's a myth as well that there's a lack of understanding on the part of the courts in the region and on the part of practitioners in the region as to what international arbitration is, or arbitration in general is. This myth, however, is focused on arbitration involving states or state parties. And the history and the precedents of commercial arbitration in Latin America and the impact of on the approach to international arbitration is usually forgotten or left to those studying comparative law. As a first remark that I would make is that the concept of Latin America cannot be approached as encompassing a group of countries as if they were one and the same. We need to attempt to find their affinities and their differences. Their differences because, as you probably all know, Latin American countries were colonies from Spain, Portugal, France, the UK, even the US in the case of Puerto Rico. Second, because there are substantial differences in migration. You have substantial Asian migration, for example, in Brazil or Peru. You have Italian and British migration in Argentina. You have a totally different type of migration, almost no migration in some areas in Bolivia, but mostly indigenous communities, and so on and so forth. So that makes a hell of a difference as to the approach to the law and to international arbitration. And in addition to that, some of the countries of the region approached more the French model of legal institutions, particularly the adoption of administrative law, administrative contracts, administrative acts, while other countries in the region have a more international approach, more civil approach, with a bunch or a group of civil laws, not administrative law, and not specialized courts for administrative law. Arbitration between private parties in the region is not new. You can find cases of international arbitration as back as 1532 in the period of the Spanish laws in the region. And if you look at the laws in Colombia, Peru, Ecuador, Venezuela, you will find laws that date back to the 19th century, referring to arbitration. But if you look at the evolution of arbitration in the region, you will find what are the different cultures in the different countries. And you will find that there are even different cultures within the same country. In some jurisdictions, arbitration was viewed, as is still being viewed, as a means to decide disputes between private parties, as a contractual way of solving disputes between private parties. While in other jurisdictions, arbitration evolved as a means to reduce the workload of the courts. So in that second approach, it has a sort of a judicial approach to arbitration. That's one main difference in the approach to arbitration in the different countries in the region. The second is that arbitration under this judicial theory was considered a sort of an alternative method to the judicial system and a limited derogation from the jurisdiction of what Latin Americans countries, or some Latin American countries, call the natural judge. The local court seem to be the natural judge, and arbitration is an exception. So in case of doubt, as result of the arbitration clause, the court would prevail. Another one is an uneven adoption of arbitration rules by arbitration centers. Some have adopted international rules, other rules that resemble procedural rules in the courts. And last but not least, the elevation of arbitration to constitutional rules as a means to protect arbitration that, as we will see, has ended up in something that I would see as main problem to have a seat in Latin America. Now, there is indeed a substantial increase of practitioners with a training in international transaction and international arbitration in Latin America. And these practitioners, and that would include Alfredo and myself, who have discussed this a number of times, we have had to struggle with the practices of what we call the local kings of procedure. So in some jurisdictions, international view seems to be prevailing, Mexico and Peru, for example. In other, a compromise has been necessary between the procedural theory and the international approach, as in the case of Colombia and Chile, where we have a dual approach to arbitration. And some countries still maintain a heavy procedural and formalistical rules, like Ecuador and some Central American countries. There's an uneven approach from the courts as well, some with a truly international approach to arbitration, some with a local approach, and some with a mixed approach, where they have an international approach to the recognition and enforcement of awards, but a pretty procedural and local approach to the actions to set aside, which is, for example, the case of Colombia, and an international approach to arbitration in the actions to set aside, like Mexico or Uruguay or Chile. There's a growth of local arbitration centers that are attempting to compete and offer a truly international arbitration. They are creating new rules. The American Arbitration, the Latin American Arbitration Association has issued now a protocol for virtual hearings to try to train practitioners in the region to properly conduct a virtual hearing. But I would say that in arbitrating in Latin America, there are two issues that must be overcome to have a truly international arbitration in the region and to really trust the seats of arbitration. Number one, the elimination of the resort to constitutional actions as additional means to attack arbitral awards. Constitutional actions known as amparo and tutela. There are a few countries that do not have that. Brazil has something called the mandado de segurança, which is a constitutional action, but as far as I know, has never been used in arbitration. Chile does not have the constitutional approach to arbitration or these sort of actions. But unfortunately, seats like Mexico, seats like Colombia, and to some extent Peru, still have issues with this tutela. The second is the perception that arbitrators are judges. That's something that we need to overcome, because to the extent that arbitrators are considered judges, in some jurisdictions, arbitrators may be considering whether to sit in a given jurisdiction in Latin America if they are to be deemed judges with the responsibilities and the duties and the obligations of the judges. To conclude, I would say that there is a lot to be done still. Latin America today can be portrayed as an exporter of arbitrators, an importer of awards. And the key thing to do in the region is to train judges. That by training judges, we can overcome problems that I have summarized in these brief remarks. I would say is the key issue to have seats in Latin America be.
Thank you, Eduardo. So speaking and continuing to address seats in Latin America, our next speaker, Alfredo Goulart, who is also a leader in the region, will tell us about challenges and opportunities for foreign arbitrators in Latin America. Alfredo.
Thank you, Julie. Thanks for the invitation to SIAC to share this panel with some distinguished practitioners. I agree with what Eduardo has just said about, he gave a very complete explanation of the situation in Latin America. Latin America is a particular region in terms of diversity. Diversity is the rule, and arbitration is not the exception. We have diversity is also the rule in arbitration. We have very different practices, very different environments, but on the other hand, interesting tendencies are happening around the region. One of the symptoms of that is the continual increase of the participation of foreign arbitrators in Latin American cases. At the end of the 90s, I received my first appointment as an arbitrator. it was a domestic case. Arbitration was something strange, and mainly the rules that we apply were the civil procedure code rules to deal with the procedure. It looks more like a trial than in front of an ordinary court than a really true arbitration case. The first foreign arbitrator I met professionally was at the beginning of the 2000s. It was Eloy Anzola. I was appointed almost by accident in an ICC case. Originally, we were 3 Peruvians, regardless of the fact that it's an international case, and the reason is because the applicable law is Peruvian. Eloy was appointed because of the resignation of the chairman, and he totally changed how the tribunal was dealing with the case. And I learned a lot about, in that case. That happened less than 20 years ago. And I will say that it is even, we are even facing the same situation in many cases in Latin America, but things have changed a lot in different aspects. 20 years ago, even domestic arbitration was strange. International arbitration was almost inexistent in the region, and foreign arbitrators in Latin America were almost an accident. The developing of the foreign investment and international commerce creates the need for international system of dispute resolution. And you can see the numbers. For example, Asia, total trade with Latin America keeps growing. It was gone from 62 billion in 1995 to 445 billion in 2016. International system of dispute resolution require impartial and independent bodies, as you know. And international investment and trade creates the need of international arbitration and creates the demand from foreign arbitrators. Because independence and impartial bodies require equidistance from the parties, and that requires equidistance from the nationality of the parties. So that begins to create the need of having more foreign arbitrators in the region. And we experience the same phenomena that we have experienced in almost all around the world about the relation between investment, trade, and arbitration, international arbitration. But that way was not an easy way. At the beginning, it was assumed that to act as a lawyer in our country, you need a law degree in Peruvian, Brazilian, or Chilean law, depending on the country you are. And you have to be incorporated in a bar of that country. Because we see the arbitrator as a lawyer using the applicable law, we assume that arbitration has to be a local lawyer. That was what happened 20 years ago. The typical argument when you propose to have a foreign arbitrator is the tribunal has to apply Chilean law, we need a Chilean arbitrator. But that has changed, that's changing now. One of the main points is the spread of the uncitual model law around the region. It was a very important step. In Latin America, Argentina, Barbados, Bolivia, Chile, Colombia, Dominican Republic, Guatemala, Jamaica, Mexico, Nicaragua, Panama, Peru, and Uruguay are based in the uncitual model, and in some countries it's partially based as Brazil, Costa Rica, Ecuador, El Salvador, Honduras, and Venezuela. So we have the model law all around the region, and that has helped a lot because the model law do not require a nationality, and the rules are more flexible and allows you to have with more frequency foreign arbitrators. In some cases, as in my country, we have a money system. We have the same rules for international and domestic arbitrators, and that works pretty well. It opened and increased the participation of foreign arbitrators, even in domestic cases. Since we adopt the model or arbitration law as the basis of our law, the foreign arbitrators in Peru have increased exponentially. And that is more interesting that happened not only in international cases, but also, as I mentioned, in domestic cases. I will say that for sophisticated cases with the participation of sophisticated law firms and parties, the rule is to have foreign arbitrators, even in domestic cases. And a similar experience, I have found similar experience around Latin America, particularly in Central America. I have some experience where that is also the practice in sophisticated cases. Some years ago, we were in an arbitration conference with Eduardo Zuleta in the Lima Chambers of Commerce, the most important arbitration institution in Peru. And in a break, we walk around the building. We were looking at the hearing rooms, and there were two hearings taking place in the chamber. And we were surprised because of the 6 arbitrators, 5 were foreign arbitrators, and one of the cases is a domestic one. So that is not strange. That is something that is happening, particularly so there is a real big opportunity to increase and to have foreign arbitrators in this kind of cases. This have also an important effect in practice, in the practice of arbitration. The interaction among local and foreign arbitrators allow locals to get familiar with international practice, how to organize a procedure calendar, having 2 rounds of memorials, organizing the rules of the hearing, the declaration of the witness, the intervention of the witness and the expert, and that change began to be copied even in small domestic cases. And once local arbitrators learn international practice, they turn in potential arbitrators to the international practice. So there was a very positive effect of this. It was unthinkable to have 20 years ago an ICC office in Brazil, or having the SIAC in New York focusing in a seminar like this in Latin America. That was unimaginable 20 years ago. But, and there are some risks. No? The first one is that some countries are reacting with regulations, mainly imposed by local practitioners, that they do not want the participation of foreign arbitrators. For example, in Peru, maybe one of the countries in the world with more arbitrations per capita, there is a project of law trying to impose a regulation requiring foreign arbitrators to register their university law degree title in SUNEDU. SUNEDU is a governmental university regulator. That will be a barrier to foreign arbitrators in domestic cases where, as I mentioned, it is relatively common to have foreign arbitrators. In the case of state parties, governmental parties in arbitration, there are some regulations creating some sort of barriers. It is not forbidden to participate, but you have to take, for example, a course in administrative law. And if you don't take the course, you cannot be an arbitrator in some cases. Even with that, some very well-known arbitrators as Roque Caivano or Segimundo Navarro have taken that course to be able to participate in Peruvian cases. The second risk is what I would call the dengue effect. In the past, I was asked for foreign friends from the United States or Europe planning to visit Latin America for tourists if there is a risk to get dengue. Dengue is a mosquito-borne tropical disease caused by the dengue virus. The dengue sounds like an unpredictable disease for them. Unpredictability brings uncertainty, and uncertainty deters people from coming. In ALARB, we create a task force to study rules for immunity, which I think is a sort of, we're facing some sort of dengue problem. The research show that the only rule about liability of arbitrators is that there is not a clear rule. No? Every country has different approaches. Some consider arbitrators as Eduardo mentioned as judges. Others have specific crimes for arbitrators in their criminal codes. Some do not have any rule, and that creates some uncertainty. So the task force is trying to focus in creating rules and practices to reduce that risk, propose changes in rules of international arbitration institutions, in laws, and maybe in treaties to make that more predictable and avoid the deterrence effect that can be caused by the lack of immunity or protection of liability by arbitrators in a region where it is not clear, and it is a consequence of we are diverse, we are even diverse in that kind of rules. So finally, if you want some advice, I think that the tendency will continue, even with these problems, the tendency continues to have a bigger participation of biggest numbers of participation in foreign arbitrators in the region. So if you want advice, if you are an international arbitrator, knowing Spanish and Portuguese gives you a great opportunity to find new cases. And if you don't know how to speak those languages, study them, it's worth the effort. Thank you very much.
Thank you, Alfredo. I think my takeaway from your talk is that Professor Lawrence Vu and Alvin Yao can expect an invitation from you and Eduardo to join them on Latin American tribunals, and that you will continue to work on protecting their immunity and do all that good work in the region. We're going to be now asking Alvin Yao to speak to us about investor-state arbitration at SIAC. You heard Eduardo Zuleta earlier mention that we have these two worlds in international arbitration, the world of commercial arbitration and the world of investor-state arbitration. So inside SIAC, Alvin, what can you tell us about investor-state arbitration?
Thanks very much, Julie. Good morning and good evening to all of you. I am very happy to be here, but also mindful of the fact that I'm probably the last speaker standing before, for those of you in the Americas, a good lunch, and for those of you in Asia, probably a good night's sleep. So I will try to be succinct. I'm going to talk about investment arbitration at the SIAC, not necessarily in Singapore, but under SIAC investment arbitration rules. The SIAC was in fact the first private arbitral institution to introduce a specific set of rules for investment arbitration, although some others have since followed suit. And this is probably driven by a couple of factors: the desire to make Singapore a seat for more and more investment arbitrations, which in a sense follows on from their success as a seat for commercial arbitration, and in recognition to the growing trade flows around all over the world. And between Latin America and Asia, I think that's no exception. You heard the figures from Alfredo, and in many ways, the opening of the SIAC's Latin American office is timely. So what do these investment arbitration rules provide? They actually contain concepts and which many of you will be familiar with. For instance, like providing for the early dismissal of claims which are manifestly without merit. That's borrowed from the ICSID rule 41.5, and that can be found in our rules at 26.1. But we've also brought in some of the rules from, if you like, drawing on our experience of commercial arbitration. Some of these relate to shorter timelines, which is something that SIAC prides itself on resolving or helping parties resolve their disputes timelessly. So for instance, if one side doesn't nominate the arbitrator, the SIAC will nominate that arbitrator within 35 days, compared to, for instance, 90 days under ICSID Rule 4. We also do provide for emergency arbitrator provisions, which is something pretty useful when you need to seek urgent or interim relief. And it deals with the issue of confidentiality, and perhaps going a little bit against the grain of the traditional investment in arbitration position of public hearings. The default position under the SIAC is confidentiality, but it does provide, this is unless the parties agree otherwise. And it also seeks to balance that up by allowing publication of awards, albeit with not containing the actual names of the parties, but their nationalities and the state involved. I then wanted to just talk a little bit about the Singapore court's approach to investment arbitration, because what Lawrence talked about was very important, which is to what extent you want the judiciary to support arbitration. You certainly don't want them getting in the way and intervening too much. At the same time, you need their assistance from time to time. So just very briefly, there have been a number of cases in the Singapore courts, which actually show the Singapore court's ability and willingness to engage in these concepts of investment arbitration in order to support Singapore as a center for investment arbitration. Allow me to mention a couple. one of the first cases, the first case they did, and which was privileged enough to be part of, was the government of Laos versus SANA, which concerned jurisdictional challenge. And it involved consideration, or rather application, of the moving treaty frontiers rule, as well as the critical date doctrine, because the Laos government sought to adduce evidence of two notes verbal, two diplomatic letters from their embassy in Laos and the PRC embassy in Laos and the Foreign Affairs Ministry, to take a certain interpretation of the PRC Laos BIT. And the Court of Appeal in Singapore, overturning the High Court, which had reversed the finding of jurisdiction. So in other words, it restated the finding of jurisdiction, considered the critical date doctrine and held that essentially evidence that comes after the dispute has already arisen, which has the effect of essentially contradicting the prior position, is given less or little weight, or no weight. It also concerned a fork in the road provision, which those of you who are familiar with the sort of Latin American jurisprudence like SIAC-ALARB and Peru dealt with, and in fact followed the approach of SIAC-ALARB of adopting a fairly broad interpretation so that any disputes involving expropriation would come within the scope of jurisdiction, not just those amounting a dispute on quantum. Another case, Suspra and Lesotho, concerned issues of jurisdiction and had the Court of Appeal analyzing, if you like, what was required for investments, admission of investments, and disputes which arose out of obligations. And in doing so, they actually held that there had to be a territorial nexus, because in this case, the particular obligation that was in issue was a right to refer a prior dispute to international arbitration. Now, my purpose in mentioning these cases is not to really debate the rights and wrongs of the decision. So in fact, I was on both cases, so I won on Sanam and lost on Lesotho. But really to just show you that the Singapore courts are trying to adopt the approach of dealing with these issues, if you like, consistent with the best international law practices, and also being very judicious about when they intervene and don't intervene. And that's really what you want from the courts. So Eduardo has mentioned some issues about possible seats, and so has Alfredo. So if you think about it, if you have a dispute, particularly involving an Asian party or an Asian state, it might make a lot of sense to go for SIAC investment arbitration, whether the seat is in Singapore or somewhere else, like in Latin America. And so my parting shot was, if you look at my virtual background, I've got the sort of skyline of Singapore. It's really quite a nice place to visit, even though I should tell Alfredo that we do also have mosquitoes that can pass dengue. So I should probably get from him some tips on how to increase the immunity of anyone who visits. But I do hope many of you will find the chance to come to Singapore, whether to conduct an arbitration or just to visit. Thanks very much.
Many thanks, Alvin. It is incumbent upon me to close this program, and I really couldn't do that without noting the tremendous initiative of SIAC, which is really a sort of a hallmark of that institution in bringing us together today for this program. I always learn from my colleagues, and today was no exception, particularly given that at the initiative of SIAC, we had put together such a stellar panel of practitioners bringing us their perspectives from Asia and Latin America. So I want to thank all of them for their experience and their wisdom. And I also want to thank all of you for joining. And maybe Professor Lawrence Bu was quite right in that we may continue to be seeing each other, even if after the pandemic is resolved, in these online sessions, because they do have a unique way of facilitating us getting together, particularly from different parts of the world during different time zones. So many thanks to all of you again, and we'll be in touch.
Thank you all. Thank you for this very interesting and insightful session. We hope to see you again in future SIAC events. If you have any question, Adriana Uzon and me, Eugenio Gomez Chico at SIAC Americas are happy to answer. Please don't hesitate getting in touch with us. Thank you.